We are back on the record in cause number 252-6407, State of Texas versus Sierra Torrance. Please, guys, if you announce yourselves for the record. State.
State Kelsey Stiegler.
The state William Thomas.
Anna Edie for Ms. Torrance.
We have reset this thing at least 4 different times, I would imagine, because of this bond violation. One, I guess, evidentiary reason for Ms. Edie to get evidence. Last time we were here, we were going to have a hearing. Unfortunately, we didn't have our pretrial services officer here. She's here now. So that's why we're having this hearing now to determine whether there is a true bond violation. Ms. Torrance is on bond for DWI that was initially filed August 28th of 2024. It's a second offense. So she was ordered to obtain a guardian interlock, or if she was not going to drive, obtain a portable device, and to blow in this portable device as according to the below schedule. Our first bond violation report was filed October 8th of 2024. And I'm correct in saying that no action was taken on that bond violation.
She was admonished and
I admonished her. We did not do anything at that time.
Could you please describe the bond conditions?
Yeah, you want me to read all of them? Or do I go over them? Yes, we don't have to check. Yes. So we have defendant shall personally appear in court on time every time the court, this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? Doesn't she have a portable device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look at that?
Sure.
Yes, please.
These are not the most recent bond conditions that have been placed. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first 2 conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, will you let me attend these updated?
Sure, of course. So 2, I guess states 2 would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
And I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
I'm asking the witness.
Sure.
You recognize that?
Yes,
Is that called?
it's the bond violation report.
The fair and accurate representation of the bond violation report.
Yes.
All right, could you please explain the violations of?
Objection, she's reading from something that hasn't been admitted yet.
Mistake, Your Honor. I can tender this to the defense.
Oh,
This will be admitted as state's exhibit number 2, Your Honor.
Okay,
no objection.
all right, it'll be admitted.
Can you please read where it says details of the violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
Wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Okay, but there's no way to know that that device is working properly from your personal knowledge.
For me to validate if it's working
Mhm.
correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
Okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, I guess argument. Or do you have any more witnesses?
No, Your Honor.
Do you have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in county court at law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that, and we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs as with
Yes,
regard to
Your
this,
Honor.
not anything else.
Okay,
All
well-
in- okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, it's, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's time. All right, I'm revoking her bond. She goes with you.
That moment hits hard. You can hear the judge's disappointment. He doesn't want to lock her up, but he feels he has no choice. Courts can't keep giving second chances when someone keeps ignoring the rules. This is what accountability looks like. For Sierra, this wasn't just about missed tests. It was about showing the court whether she could be trusted, and in the judge's eyes, she failed that test. Literally and figuratively.